Some cases are remembered, not only because of what one person did, they are remembered because of what a system failed to see. In London, beneath the soft glow of street lamps and the quiet movement of black taxis through wet evening roads, a number of reports once sat apart from one another. Different dates, different voices, different places. At first, they did not look like one story. One woman remembered a strange journey. Another described a similar pattern. Another detail appeared, then another. A licensed taxi. A familiar type of vehicle. A driver who seemed ordinary enough. A story told to create trust. A moment that later felt wrong. But tonight, we are not going to enter the details of the offenses. We do not need to. The part of this case that matters for this sleep-friendly telling is quieter, slower, and in many ways more important. It lies in police files. It lies in missed connections. It lies in covert surveillance. And later, it lies in a legal rule that kept parole decisions hidden from the very people who most needed to understand them. This is the story of John Worboys. But more deeply, it is the story of an investigation that arrived late, a justice system forced to look again, and a loophole that changed the way England and Wales thought about parole, secrecy, victims, and public confidence. Welcome to a calm, true crime story for sleep. Tonight's episode is told slowly, respectfully, and without graphic detail. This is not a retelling built around fear or shock. It is a careful look at how a serious case was investigated, how patterns were eventually recognized, and how a later parole decision exposed weaknesses in transparency and public accountability. The focus is not on the offenses themselves. The focus is on the police investigation. The focus is on the hidden work of surveillance and evidence gathering. And the focus is on the legal question that followed years later. When a parole board makes a decision in private, who is allowed to know the reasons? You can let your eyes rest. The story will move gently, and we will follow it, not through sensational detail, but through process, documentation, and the quiet, unsettling question at the center of the case. Why did the light arrive so late? London has always had a nighttime rhythm of its own. By day, it is glass offices, railway stations, bridges, crowds, buses, and footsteps moving quickly through narrow streets. By night, the pace changes. Roads shine after rain. Pub doors open and close. Theatre districts empty slowly. People wait outside stations, restaurants, hotels, and late-night venues, looking for a safe way home. For many people, the London black cab has long carried a special kind of trust. It is not just a vehicle. It is part of the city's identity. Licensed black cab drivers are associated with regulation, knowledge of London streets, and a public role that feels familiar and safe. That trust is one reason this case shook public confidence so deeply. John Worboys was a licensed London black cab driver. He was later also known as John Radford. In public reporting and legal discussion, however, the name John Worboys remains attached to the case. In March 2009, Worboys was convicted at Croydon Crown Court of 19 serious offences involving 12 victims. In April 2009, he received an indeterminate sentence for public protection, with a minimum term of 8 years, less time already spent on remand. The High Court judgment in the later parole case records these facts clearly, but the number of convictions is not the whole story. In cases like this, the known criminal case can be only one part of a much larger system failure. Before the conviction, there had been reports, there had been warning signs, there had been separate accounts that, when viewed alone, could seem difficult to interpret. But when placed side by side, they began to suggest a repeated pattern. That is where this case becomes not only a criminal case, but also a case about investigation. How does a police force recognize a pattern across separate reports? How does it treat accounts that may contain uncertainty, gaps, or hesitation? How does it avoid putting each report into a separate box? when the truth may only become visible once those boxes are opened together. Those questions became central to the public understanding of the case. They also became central to later legal challenges, because this case was not only about what was eventually proven in court, it was also about what might have been understood sooner. This section will remain brief. The purpose of this episode is not to describe the offenses. What matters for the investigation is the pattern. Across a number of reports, women described experiences connected to taxi journeys in London. Some accounts included a black cab, a driver who presented himself as friendly, a story about good fortune or money, and later, confusion or concern about what had happened. Those reports were serious, but they were not always simple to investigate. Some people who came forward were uncertain about parts of their memory. Some did not report immediately. Some had only fragments. Some may have doubted themselves before they ever spoke to police. That matters, because when someone reports something serious but cannot give a neat, complete, linear account, the system around them becomes extremely important. Investigators need to know how to listen. They need to know how to preserve information. They need to know how to compare one report with another. And they need to know that uncertainty in a victim's memory does not automatically mean there is nothing to investigate. In the Worboys case, the eventual investigation depended on recognizing repeated features. A single report might be difficult to understand. 2 reports might raise concern. Several reports with shared details can become something else. They can become a pattern, and once a pattern appears, an investigation changes. It is no longer only about one incident. It becomes a search for connection. In a complex investigation, there is often a quiet turning point. It is not always dramatic. It may happen at a desk. It may happen when one officer notices that a phrase in one file sounds like a phrase in another. It may happen when a vehicle description, a location, a time of night, or a method of approach begins to repeat. The investigation into John Worboys eventually moved in that direction. Separate reports began to look less separate. Details that once seemed isolated began to line up. And once the possibility of a repeated pattern became clearer, police had to move from receiving reports to actively testing a theory. That required evidence. It required surveillance. It required careful handling of witnesses. It required checking taxi records, movements, locations, and accounts. A taxi is a difficult subject for surveillance. It is not a fixed address. It does not stay under one streetlight. It moves through the city, disappears into traffic, turns corners, waits, stops, and moves again. A black cab in London can be highly visible and almost invisible at the same time, because it blends into the ordinary life of the city. That is what made the covert work so important. Investigators needed to observe without alerting the suspect. They needed to understand habits. They needed to look at where he worked, when he worked, and how he interacted with passengers. In this kind of investigation, pattern becomes a map. Not a map of streets, but a map of behavior. Where does the person tend to appear? What kinds of locations are involved? What time of night? What kind of story is used? How does the person create trust? Which details repeat across different accounts? A criminal investigation often depends on physical evidence, but it also depends on structure. It depends on whether investigators can arrange many small pieces into one coherent picture. That is what eventually happened. Worboys was arrested in 2008 and convicted in 2009. The later High Court judgment records that he was convicted of 19 serious offenses committed between October 2006 and February 2008, involving 12 victims. But the conviction did not end the questions. In fact, it sharpened them. Because once a pattern has been proven, people naturally look back and ask whether the same pattern could have been seen earlier. That question is not simple. Police investigations happen under pressure, with incomplete information and imperfect systems. But in this case, the concern was not merely that one officer missed one clue. The concern was broader. It was about how separate reports were assessed. It was about whether information was properly shared. It was about whether the seriousness of earlier accounts was fully understood. And it was about whether assumptions had affected the way those reports were treated. The disturbing part of a system failure is that it may not look like one enormous mistake. It may look like many smaller decisions. A report not linked, a detail not searched, a concern not escalated, a file closed too soon, a pattern left unseen because no one was looking across the whole field. This is why the police investigation became such an important part of the Worboys story. It was not only about catching one offender, it was about understanding how a large public system can fail to connect the information it already has. And that lesson did not disappear after the criminal trial. Years later, it returned in another form, not through a new police search, not through a new covert operation, but through the Parole Board. In December 2017, the Parole Board decided that John Worboys, by then legally known as John Radford, could be released on license. The news became public in January 2018. The reaction was immediate and intense. For many people, the issue was not only the decision itself, it was the secrecy around it. People wanted to know what evidence the Parole Board had considered. They wanted to know what reasons had been given. They wanted to know whether the wider pattern of alleged behavior had been properly placed before the panel. The Parole Board does not retry the original criminal case. It does not decide whether the original sentence was too harsh or too lenient. Its role is to assess risk. The Ministry of Justice Review explained that the Parole Board cannot assess whether the original sentence was suitable. It assesses release based on the prisoner's risk to the public. That sounds technical, but it is central to the case. If parole is about risk, then the quality of the risk assessment depends on the quality of the information available. A panel can only evaluate the material placed before it. If the material is too narrow, the decision may also become too narrow. If the file focuses mainly on convictions, but does not fully explore wider alleged patterns relevant to risk, the assessment may miss something important. This became one of the great questions of the Worboys parole controversy. Was the Parole Board looking at the fullest possible picture? Had it received enough material? Had it asked enough questions? Had it properly considered whether Worboys' own account of his offending was limited in a way that affected his credibility and risk? Two women, known in the legal proceedings as DSD and NBV, challenged the release decision. The Mayor of London also brought proceedings. The High Court later described the case as exceptional, noting that a release direction had not previously been challenged in this way. In March 2018, the High Court quashed the Parole Board's decision. The court held that the board should have made further inquiry into the circumstances of Worboys' offending and into the limited way he had described it, because that could affect his overall credibility and the assessment of risk. This was not a simple matter of public anger, overruling a legal process. It was a judicial review. That means the court was examining the lawfulness of the decision-making process, and the court found that the process had not been good enough. The case was sent back to be considered again by a different Parole Board panel. The Parole Board then stated that it would not challenge the outcome and that the case would be re-referred, describing it as unusual and complex, and saying that any decision should be made on the best possible evidence. That phrase matters. The best possible evidence. In an investigation, the best possible evidence helps reveal what happened. In Parole, the best possible evidence helps assess future risk. In both settings, missing information can change everything. The legal loophole at the heart of this case was not hidden in a dramatic place. It was found in a rule. Rule 25 of the Parole Board Rules 2016 created a broad restriction on releasing information about parole proceedings. In practice, this meant the Parole Board was prevented from publicly explaining much about the decisions it made and the reasons behind them. The Ministry of Justice Review later described the rule as a blanket prohibition on the release of information about proceedings and the people involved. The purpose of privacy in parole is not meaningless. Parole files can include sensitive information. They can include personal data, psychological assessments, information about victims, license conditions, and professional reports. A parole system cannot simply publish everything. Privacy has a real function. But in the Worboys case, the rule went too far. It did not merely protect sensitive details. It prevented meaningful public understanding. It made it difficult for victims to know why a release decision had been made. It made it difficult for interested parties to assess whether there were grounds for a legal challenge. And it made it difficult for the public to trust that the process had been robust. The High Court concluded that Rule 25 went too far. The judgment said there was no objective necessity for a rule that suppressed all information relating to parole board proceedings, regardless of the public interest in a particular case. This is the quiet legal center of the story, not the taxi, not the streets, not the courtroom drama. A rule about secrecy, a rule that made it hard to see the reasons behind a decision, a rule that had to be changed because a system built entirely behind closed doors could not maintain public confidence in a case of such seriousness. After the judgment, the Ministry of Justice reviewed the law, policy, and procedure surrounding parole board decisions. The review said the Worboys decision had shaken confidence and put a spotlight on the parole process. It proposed greater transparency, including amending Rule 25 to remove the blanket ban, creating a mechanism for reconsidering some release decisions, and improving victim involvement. That did not mean every detail would become public. It meant the system had to move toward a better balance. Enough privacy to protect sensitive information. Enough transparency to allow scrutiny. Enough information for victims to understand the process. Enough openness for the public to see that decisions about risk were being made carefully. In this sense, the Worboys case became bigger than one prisoner. It became a case about the architecture of justice. How much should be hidden? Who gets to know the reasons? When does privacy become opacity? And when does opacity become a risk of its own? Those are not loud questions. They are slow questions, but they matter. Because a justice system is not only judged by the sentences it gives, it is judged by whether its decisions can be understood. It is judged by whether people affected by those decisions are treated as if they matter. And it is judged by whether it can admit that a rule, once defended as routine, has become incompatible with open justice. The John Worboys case is not unsolved in the ordinary sense. There was an investigation. There was a trial. There were convictions. There was a sentence. But the case remains unsettled in another way. It remains unsettled because of the questions it left behind. Why were earlier reports not connected sooner? Why did a pattern take so long to become visible? How can police systems be improved so that separate voices are not left isolated in separate files? How can parole panels be sure they are seeing the fullest possible picture of risk? And how can a justice system protect privacy without hiding its reasoning from the people most affected? In 2026, The Guardian reported that Worboys had again been denied parole and was also refused a move to open prison conditions. That later decision shows that the parole question continued long after the original trial and long after the 2018 controversy. But the deeper legacy of the case is not simply that one man remained in prison. The deeper legacy is that the system had to change. The police investigation showed the danger of missed patterns. The parole challenge showed the danger of excessive secrecy. And the legal reforms showed something quieter but important. A justice system can be forced to learn. It can be forced to open a closed rule. It can be forced to explain itself. It can be forced to listen again to people who were once kept outside the room. Tonight, as we leave the case behind, the image that remains is not one of shock. It is a city at night, a file on a desk, a report waiting to be connected to another report, a decision made behind a closed door, and then, slowly, that door opening just enough for the public to ask, what was known? What was missed? And why did the light arrive so late? You have been listening to a calm, true crime story for sleep, focused on investigation, law, and the systems that surround a case. No graphic detail was needed. The story was not about fear. It was about process. It was about evidence. It was about the importance of listening carefully, connecting information, and making decisions that can withstand scrutiny. As you rest now, let the details soften. The files are closed for the night. The city quiets, and the lesson remains simple. Justice needs truth, but it also needs enough light for people to see how truth is handled. Sleep well.